morning. On behalf of the Georgetown Center for Business and Public Policy, I'd like to welcome you to this panel discussion. My name is Brad Jensen. I'm a professor at the McDonough School of Business at Georgetown University. I'm also affiliated with the Georgetown Center, and on behalf of me and the Center, I'd like to welcome you. This is a particularly important time to talk about fresh thinking in telecommunications and internet policy. If anyone has been paying attention to either the popular or the trade press in the telecommunications and internet space, we know there's a lot going on. The transition to IT telephony, the upcoming incentive auctions, universal service issues, spectrum sharing, how to handle issues in the internet space in international arena, data flows, not to mention the potential rewrite of the Telecommunications Act. So there's a lot on the table. With so many things on the horizon, we at the Center believe that now is an opportune time to take a step back and take a look at fresh thinking and fresh ideas about how to deal with this broad basket of issues. To foster this discussion, we are delighted to have just a terrific program this morning. We will start with remarks from the Acting General Counsel of the Federal Communications Commission, Jonathan Sallet. Jonathan's bio is in your handout, but let me just mention that Jonathan has a deep history in these issues. He has worked in private industry, spending a fair bit of his career at MCI. He's worked in the White House, and now Acting General Counsel at the FCC. Before Jonathan talks, I would like to mention that he has very graciously agreed to take a few questions after his remarks. We are at the National Press Club, so it seems appropriate that he would do that. However, I want to point out that there are a number of things pending before the FCC, so there may be a number of things that he is not able to address. I would encourage you in your questions to focus on his remarks this morning. After that, we will turn to the panel. My colleague Carolyn Brandon will manage that. So without further ado, please help me to welcome Jonathan Sallet.
Thank you. I started at the FCC in November, which means if I close this computer, will this turn that off? Is that a problem? This will, yeah, just so I can have this in front of me. So I started at the FCC in November. That means I'm a relative rookie by commission standards. What I want to talk about for a few minutes this morning is how we will exercise the authority that's been given to us. I'm going to talk about how we hope to do it in a prudent and responsible way, and I want to start off with an example. Even though there are representatives of regulated industries in the room, I'm not asking anybody to stop using their smartphone during these remarks. I started at the FCC in November, but I want to tell you a story about my first interaction with the FCC, which was, I believe, in 1971, when I was an undergraduate at Brown University working on the radio station there, which is WBRU-FM. And I went to Boston one day, took a Greyhound bus from Providence, and went to the FCC field office that was then in Boston, and took a test to get an FCC third-class engineer's license, which I got. And this allowed me to get up at 4 o'clock in the morning, a bad time for a college student, and go to the offices of WBRU and turn on the transmitter, which was like the most exciting engineering feat I've undertaken. And so my interest in these issues go back a long time. The other thing I want to mention, because given where we're sitting today, one of these topics I studied in college was journalism, and read a lot, thought a lot about Fred Friendly and Edward R. Murrow, where it seems that we shouldn't let the chance go by to note that we are in the Edward R. Murrow room at the National Press Club. And this was a man who had a tremendous impact on America. Before he became chairman, Tom Wheeler gave me a book to read, or told me to read a book by Lynn Olson called Citizens of London, which I commend to everyone. It's a book about 3 Americans in the United Kingdom in World War II, one of whom was Edward R. Murrow, and what they did to tell the rest of the world about the dangers that were facing Europe and the United Kingdom and the world. The stories are stirring, and Murrow's bravery in the face of physical harm, almost unimaginable. Look, I assume there have been a lot of events in this room over the years. I think if we added up all the words from all the speakers, including, most notably mine, they would not equal the impact of even one of Murrow's broadcasts from London during the Blitz, during the dark days of World War II. And so it just seems to me we should take a minute to reflect on the enduring contribution that he made that leads us to remember him in the way that this room does. The other thing that happened when I was growing up in the 60s, the younger colleagues at the FCC tell me I don't look old enough to remember the 60s, although I'm not sure they say that when I'm not in the room. But one of the pastimes of students in the 1960s was to ask the question, what is the relevance of what older people are saying, right? What was the relevance of a course of instruction, of received wisdom, of tradition? That turned out to be the wrong question, and I think it led to some bad answers. The right question, which should have been asked at the time, was this: of the wisdom and tradition and instruction that were communicated to young people, what was and should be transient, what was and must be enduring. And issues of social debate in the 1960s illustrate both. The campaign for civil rights was, after all, a campaign to change what needed to be changed. Think about the Supreme Court case in Loving versus Virginia, which is perhaps the most aptly captioned case in Supreme Court history since it had to do with marriage. In Loving versus Virginia, the court encountered a social circumstance that needed to be changed, that discrimination needed to be abolished, that social practices were not just transient but had to be terminated. At the same time, the late 60s, the early 70s, people were asking about the institution of marriage. To some, that seemed like a dusty tradition, but it was and, of course, remains both fundamental and enduring. Now, I think these same 2 questions can inform our thought process. This isn't to say that the FCC's job is to think about great issues of social policy. It is not. But the taxonomy of these 2 questions strikes me as the right way to consider how the FCC can apply the law that Congress has written. I talk today as a lawyer, not a policymaker, and these are my personal views. But let me take a couple of minutes to apply this framework. What is transient about the issues that the FCC considers is technology, right? Chairman Wheeler has emphasized this in an ebook that was put out called Net Effects. He talks about 4 great network revolutions: the invention of the printing press, the railroad, the telegraph, and other forms of electronic communication that it spawned, like broadcasting and telephony, and finally the internet. We're in the middle of that 4th great network revolution, the internet, and it is the dramatic and dynamic shift to IP-based communications that is very obvious, especially in an era in which the internet seems to be the most fundamental platform of commercial, economic, social, and sometimes even personal communication. Change is the only constant, especially when you're talking about an industry that's progressed from the telegraph to the telephone to the dial-up modem and then to broadband even faster than Spinal Tap changed drummers. We are in favor of technological improvement and innovation. It's the lifeblood of American growth. And the Commission is tackling the challenges of change. In January, the Commission adopted its IP transitions order, and I want to emphasize plural, transitions. because there's more than one. Let me note three. First, there's the change of protocol, TDM to IP. Secondly, there's the change in the characteristics, the physical characteristics of network. For example, the increased use of fiber or the use of bonded cable, or, bonded copper or coax or fixed wireless. These changes are in the marketplace, and many consumers are adopting them every day, and that is a good thing. But there's a third dimension, right? The people who operate, companies who operate the traditional networks have made plain their desire to retire the copper networks that millions of Americans still use, if in declining numbers. And of course, that regulatory request isn't the addition of choice to the marketplace, it's the removal of one. No. That's the way markets work. And the FCC has a legal mechanism, Section 214 and other provisions, that provide the framework for how to think about this. But what the Commission did in its January order, and I think it's important, is to think about how it could learn before these decisions need to be made. Learn through, for example, voluntary experiments. AT&T has proposed one. There are 2 such experiments that have been filed with us thus far. Learn through the use of targeted experiments. For example, experiments thinking about the ways that deployment can be incented in rural America. These kinds of experiments, we hope, will enhance the ability of not just the Commission to learn, but of the companies themselves, consumers, competitors, and the public at large. And these experiments won't be about technology per se. That's a topic for engineers, and I don't claim my third-class license entitles me to a voice in that particular discussion. But the discussion would be about what the impact of technology can be, will be, may be on consumers and on values. Indeed, what's perhaps most important to understand about this evolution is the impact on what Chairman Wheeler has referred to as the network compact. Those values that traditionally have linked successful networks to their customers. And it is those values that come to the second part of the taxonomy that I offer, because those values answer the question, what is fundamental and what must endure. In other words, technology is transient and should be. Values are enduring and must be. Commissioner Rosenworcel helped the FCC a great deal by articulating values last September that have since been embraced by the Commission. She notes these for public safety and security, universal accessibility, competition, and consumer protection. These are the enduring values that have informed communications law, and they should be, the Commission has said they will be the values that guide the Commission as it applies the law today. And these principles are found right in the text of the Act. Title I of the Communications Act says, and I quote, "For the purpose of regulating interstate and foreign commerce and communications by wire and radio, so as to make available, so far as possible, to all the people of the United States, without discrimination, a rapid, efficient, nationwide, and worldwide wire and radio communication service with adequate facilities at reasonable charges." You can get a lot of the enduring values that form the network compact out of just that provision. The public interest standard. It's found in sections of the Communication Act that govern everything from how the Commission assesses regulatory fees, exercises forbearance authority, implements limits on commercial time in children's TV programming, and, of course, universal service policies. Then there's Section 706, which was discussed at length in the D.C. Circuit's recent opinion in Verizon versus FCC. 3 points about that decision that I think are worth remembering. First, of course, the Court upheld the Commission's interpretation that Section 706 gives the FCC substantive authority to encourage broadband deployment by, among other things, removing barriers to broadband, removing barriers to deployment, incenting competition, encouraging innovation. Thus, the D.C. Circuit ruled that the FCC had legal authority to take action. Second, the court held that the Commission had rightly identified harms within the scope of that authority, specifically upholding the Commission's conclusions that edge provider innovation leads to the expansion and improvement of broadband infrastructure, and that Internet openness fosters the edge provider innovation that, in turn, drives a virtuous circle of innovation and growth. Finally, the court concluded that the Commission had selected the wrong mechanism in order to carry out its legitimate goals. Thus, the court vacated the so-called no blocking and non-discrimination rules, but it did not vacate the transparency rule that the Commission had also promulgated. In explaining what the Commission was not permitted to do in the order under review, the court was also careful to explain the kind of approach that the Commission might take. Here, one takes another step back in Commission history to the so-called data roaming rules, the wireless data roaming rules, which, as the court explained in Verizon versus FCC, included a general principle, a general legal standard, commercially reasonable terms and conditions, provided additional guidance through the notation of a series of factors that would be used to decide how to apply that legal standard, and then look to case-by-case negotiation or, if necessary, dispute resolution to actually decide what the legal standard would require in a particular instance. So the third conclusion is that the Commission selected a mechanism that was not available to it in the Open Internet Order, but this very promising alternative is available. So it's not very surprising that in the aftermath of the decision, the chairman instructed the staff to bring to the full Commission a notice of proposed rulemaking that would use the means articulated by the D.C. Circuit to further the goals that the D.C. Circuit found were permissible and in the scope of FCC authority. That means the Commission will look for opportunities to enforce and enhance the transparency rule that was upheld and to fulfill the goals of the no blocking and unreasonable discrimination rules. So the Commission has opened a docket for people to put in comments about how we should move forward. It's called Protecting and Promoting the Open Internet, and thus far we've gotten almost 10,000 comments. When the public notice was put out, the Commission said it would be very helpful to get comments within the first 30 days. Those 30 days run on March 21st. We'd like to read comments that come later, but it'd be particularly helpful to have them before then. And so we encourage people to file their views so that they will be of benefit to the Commission as the staff undertakes the task allocated and assigned by the chairman. I want to take a few minutes to talk about one of the values in particular, and that's competition. You've heard, I'm sure by now, over and over again, that Chairman Wheel likes to talk about competition, competition, competition. But of course, the emphasis on competition doesn't stop with the chairman. Commissioner Pai, for example, gave a very important speech in December on the 100th anniversary of the Kingsbury Commitment, talking about what that meant and what lessons we can draw. So let me take a minute to sketch out the chairman's approach and give some examples of how I think it applies. He said, and I'm quoting, "Where competition does exist, we will protect it. Where competition can exist, we will incent it. And where private markets cannot be expected to deliver what the public needs, then we will proceed in a transparent manner to fill that void." I'd like to give examples of each. The first principle, protection of competition. Not competitors, but competition. Think of this as preventing competitive markets from being transformed artificially into non-competitive ones. Such issues can arise, for example, when we consider the transfer of FCC licenses. And in judging transactions, we should be careful to move both efficiently and to work in harmony with antitrust agencies. But it's worth noting that our authority is not exactly the same as that of antitrust agencies. Compare the Communications Act, for example, to the Sherman and Clayton Acts. And let's assume for a moment we're talking about DOJ review, although, of course, the Clayton Act can be enforced by both the FTC and the DOJ. The DOJ's review is focused on the competitive impact of an acquisition without reference to the broader public interest. But the FCC's competitive analysis under the public interest standard can consider, for example, whether a transaction will enhance rather than merely preserve competition, and thus takes a more expansive view of competition, innovation, and their potential impact. Secondly, Congress has enacted a different process for the FCC to use than the ones employed by the antitrust agencies. Using the Department of Justice as an example, again, as you know, under the Clayton Act, the Department of Justice must decide whether it will file a civil action in a U.S. district court in which it bears the burden of proof. Congress has mandated a different process for the FCC. If after the FCC makes a thorough review, the Commission is unable to find that the proposed transaction serves the public interest, if the record presents a substantial and material question of fact, then we are obligated to designate the application for an administrative hearing, at which the facts of the transaction can be examined through a traditional adversary process. After that, of course, the Commission can render a judgment and judicial review can follow. And I want to take a minute to address one potential misconception about how the FCC transactions process works. There are some people, I think, who suggest that the FCC's answer to transactions is always yes, and the way to get to yes is through negotiation between the FCC and parties. It's difficult to think that that view can be squared with the FCC's actions in transactions that include AT&T, T-Mobile, and the Comcast NBCU transaction, but in case there's any doubt, let me just say this. Chairman Wheeler is very clear that transaction reviews under his tenure will be rigorous, fact-based, thorough, will follow Congress's statutory mandate. And I mean that both as to the applicable legal standard and the process to be used, and will serve the public interest. Now, I believe that to be important because the FCC has expertise that we bring to the table that adds value to the review of such transactions. Jonathan Baker, for example, has talked about how the conditions and divestitures on transactions like Comcast NBCU allowed the Commission to remedy potential anti-competitive harms that the DOJ might have had difficulty addressing. My friend Phil Weiser has written about successful cases of FCC merger review. This particular expertise found in this expert agency is, I believe, an important part of understanding the sweep of innovation and competition and the manner in which it can be affected by transactions. Another example, a recent example that's worth thinking about, has to do with a statement that the chairman made this Monday having to do with media. That concerned joint negotiation of retransmission consent agreements and attribution of certain so-called JSAs, joint sales agreements between and among broadcasters. I want to talk about the proposed limitation on joint negotiations. What the chairman explained was that at the March meeting, the Commission would take up an item that would prohibit top 4 stations in a local broadcasting market from working together to negotiate retransmission fees with cable or satellite systems. In this kind of situation, the two broadcast stations are competitors. For example, they may be network affiliates of networks that are competing against each other. They may be competing on the basis of local news or weather coverage. They're certainly competing, one would imagine, in the market for local advertising. So joint negotiations can only be expected to artificially drive up prices to their customers without supplying significant, if any, pro-competitive efficiencies. It is to protect competition that the chairman wishes to prohibit this form of joint negotiation. The second principle is, where competition can exist, we will do more to incent it. And let me just briefly note here that the commission, the chairman, are very focused on spectrum, right? Spectrum is, as everybody knows, the key input into wireless competition. There are important proceedings coming up. The incentive auctions, which will be held in 2015, combining a reverse auction with a forward auction in order to bring nationwide repacked spectrum to wireless broadband services. In late February, the Commission completed its first major spectrum auction since 2008, raising more than $1.5 billion for licenses to use 10 megahertz of spectrum that until fairly recently was considered nearly valueless. And also on Monday, Chairman Wheeler circulated a proposal to the Commission that would set up an auction of an additional 65 megahertz of spectrum usable for wireless broadband this fall. And he's looking other ways to increase spectrum, including, I want to note, unlicensed spectrum. So Commissioner Rosenworcel gave a very important speech in early March where she talked about flexible Wi-Fi rules, doubling unlicensed bandwidth in the 5 gigahertz band, and talking about exploring the possibilities of using unlicensed bandwidth in the 3.5 gigahertz band. That's right. And on Monday, Chairman Wheeler circulated a proposal in the 5 gigahertz band that would do what Commissioner Rosenworcel outlined. We're working on proposals, the FCC staff is working on proposals to permit both licensed and unlicensed spectrum in the 3.5 gigahertz band. And we're looking at other opportunities. But incenting competition is not only, of course, a question of wireless or spectrum. The chairman has said that interconnection is a core value. After all, the internet is not a thing, it's a collection. It's a collection of networks. That's what internet means. It's between networks. And so the chairman has emphasized that interconnection is an important part of the network compact. Last point. The chairman's third principle about competition is that where private markets cannot be expected to deliver what the public needs, then the Commission should proceed in a transparent manner to fill that void. Universal service is, of course, the classic example. There are many, most, perhaps, parts of the country where broadband deployment has been and will continue to be fueled by private capital, and that's the way it should be. But simple economics tells us that markets do not own the responsibility to serve every customer. Profit maximization only goes as far as the potential to earn profits exists. But there's a larger societal interest, right? We all recall Metcalfe's law, which tells us that the addition of each single user to a network creates more than an additional unit of value. That's a very important concept because it suggests value not just to the people who are just connected, but to the people who have been users of the network as well. And that, of course, brings us to the special responsibility to consider the reach of broadband across the nation. Consider rural America, right? We all know that rural America is different because density of population is less, and that traditionally has had an impact on the ability or manner in which networks are deployed, but that's not all that's different. Rural America is a place where people tend to be older, where people tend to be poorer. And so there's a special responsibility because I believe we cannot be a nation of opportunity without networks of opportunity. That's the case for rural broadband. The targeted experiments about which I spoke before have elicited thus far almost 1,000 expressions of interest from entities like rural telephone companies, rural electric co-ops, cable and wireless service providers, schools and libraries, research and education networks, and communities themselves. Expressions of interest in learning how or exhibiting best practices in the deployment of broadband to places where it might not otherwise be deployed. So just to sum up, the core principle I suggest is this. what is transient and should be particularized technological solutions. What is enduring and must be the values of public safety, universal access, competition, and consumer protection. Those are the values that have informed the FCC's interpretation of the Communications Act. They will continue to inform us, or as my younger colleagues tell me, we will carry those on as the beat goes on. Thank you very much.
So I think Jonathan has to leave in about 5 minutes, so we'll open the floor to Q&A. Again, encourage you to focus your questions on his remarks this morning. Yes.
Good morning. I'm with the Utilities Telecom Council. My name is Eric Wagner. Oh, hi. I'm with the Utilities Telecom Council. And just to go back to one of the last things that you mentioned, in the IP transitions order, you had introduced the broadband trials and opening it up specifically to utilities. And I know our members have responded very strongly to that, submitting well over 100 expressions of interest. So my question would be, from your standpoint, how can the utilities be instrumental in providing broadband access to the underserved and unserved areas of America? Thank you.
We very much appreciate the interest, your organization's interest, and the expressions of interest that have come from you and from other sources. In some sense, if we knew the answer to your question precisely, we wouldn't be having the experiments. And I mean that in a serious way. The reason we want to do it this way is to try to collect ideas. The full commission will have to vote on the criteria for the experiments and the amount of funding. But what we foresee is pilot projects that will teach us, for example, the best way in which utilities contribute, or existing rural telephone companies, or other providers of bandwidth, because it's exactly the point of these experiments to try to give us a way to gain knowledge that might defeat common assumptions about the difficulties or inability to deploy broadband to all Americans.
Yes. Please.
Earl Comstock. My question is, given your comments about the enduring values and where the chairman seems to be trying to head, do you see anything fundamentally flawed in the current legal authority that you have? In other words, do you feel comfortable that within the bounds of the 34 Act as amended in 1996, that the FCC can achieve and protect the network compact using its available authority?
We do believe so, yes.
Good morning. Matthew Schwartz, Communications Daily. Following up on the nearly 1,000 expressions of interest you discussed for rural broadband, I've done some calculations, and just looking at like one page of 10 expressions, the total money requested is in the hundreds of millions. If you add them all up, it's in the billions. The notice of proposed rulemaking contemplated 50 to 100 million for this kind of round of experiments. What kinds of principles might the agency use to kind of decide who gets this and how best to use limited funds?
The order that we put out in January asked for comment on what's the appropriate level of funding and gave, I think, the examples that you cite, and said that the full commission would, and I think that comment cycle runs in mid-April, and in an upcoming meeting, the commission will consider your questions. So for my own part, what would be interesting to know is in areas where there is not broadband now, what can be practices, what can be ways of proceeding that we might not have expected, but might have the benefit of not only deploying broadband to an area, but teaching others how broadband can be deployed. Because given the fact that this is, as you say, a relatively smaller amount of money that the Commission talked about, the importance of these experiments will be not only in what is achieved, but what is learned by others. Anybody else? Well, I very much appreciate the chance to be here. Thank you, John. Thank you, to the Center. Thanks very much.
Thank you. So I think we'll now move to the panel discussion, and the moderator for the panel is my colleague Carolyn Brandon. Carolyn is affiliated with the Georgetown Center and is also founder of Whitworth Analytics. I didn't want to mispronounce Whitworth Analytics. Prior to that, she was a VP for policy with CTIA, and Carolyn was voted, or was awarded a top 10 women in wireless by Wireless Magazine. So happy to turn it over to Carolyn's capable hands.
Thank you all again, and thank you all for joining us. I think we've got a fantastic panel lined up with really giant brains, and I would welcome all three of the speakers to join me up here. We are going to kick things off with the esteemed Professor Jerry Faulhaber, who many of us know and some of us have actually had the pleasure of working with. He joins us from the University of Pennsylvania, and he's going to kick things off by walking through a presentation he has put together. Second, we are joined by Professor John Mayo, my boss. Know him and love him. And then we are rounded out by Larry Downs, who is a noted author, an analyst, and an observer of the tech and telecom space for many years. Also an attorney by training and soon-to-be colleague of mine at the center. So very happy to have all three here. And without further ado, Professor Faulhaber, let me turn it over to you.
Thank you. While we're waiting so that you can see what I can see, I should say when John first called me about this, I said, oh, this sounds like a wonderful topic. I'd very much like to talk to this. What would you like me to talk about? And he said, I'd like you to talk about 7 minutes. So this talk is called 7 minutes, okay? Well, actually, no, it's something more than that, I think. We'll see. I'm going to try to keep this brief and try to zip through a few slides. I want to talk about the Janikowski era for one slide. Then we'll move on to the Wheeler era. Is this thing on? It's hot? Okay, good. And then I want to have at least one slide to say, okay, what's really long-term thinking about this? Tom Wheeler has a lot on his plate, let me tell you. There's no question about that. In the Janikowski era, there was really three big issues, as I see it, okay, that his commission attempts. The first was the National Broadband Plan. If you remember that, it's back in 2009, something like that. Blair Levin was kind of the czar of that. And what came out of that? Okay. Well, this is about the time we were passing out money for the stimulus thing, and we got some money for broadband rural deployment, and there was a lot of discussion about that. One of the things, I put this sounds kind of trivial, but talk about wireless broadband. Wireless has, in a way, always been kind of got no respect. If you recall back in 2000, most people didn't think wireless telephony was a substitute for wireline. They said, oh, well, this is like you get mobility out of this, but you're never going to substitute for this. Meanwhile, people are getting wireless phones and dropping their wirelines, and I think we're up to about 35% of wireless customers no longer have wirelines, so that's no longer right. But at the time, the National Broadband Plan was being put together. People didn't think too seriously about wireless broadband. But towards the end, they did. And so, okay, look, and we can talk more about that in the future. I tend to be very gung-ho about wireless broadband. Again, pending spectrum, okay? But we didn't get too much else. And I'm going to argue that's no bad thing. The second was spectrum, and we know what the problem is there. We need lots of. Now, let me say, the most important thing that was done here was the implementation of two-sided auctions. Now, this was an invention, really, of my friends Zevin Quirrell and John Williams that goes way back to the 1980s. And they have, first of all, managed to get Congress to approve auctions and then to approve the two-sided auction, which probably getting Congress to approve anything is probably more difficult than actually having a two-sided auction. And I wish them. Now, there's also been, from the PCAST report, lots of talk about sharing with the feds. Okay? Not much has happened. In fact, saying zero has happened would be a good approximation. And in my view, none is likely. Now, the other thing that came out of this is, oh, in the two-sided auction, maybe we should have bidding restrictions. which our friends over at DOJ suggested. But basically, not a whole lot has come out of this. Okay. Now, there is one thing where we got a lot of, and that, of course, is network neutrality. The FCC finally does something, and we get the Open Internet Order. Now, in a sense, this was easy to do. All you had to do was write an order. You didn't actually have to make spectrum available or do something about broadband. All you had to do was issue an order. Now, as it turned out, the FCC was certainly bright enough to understand that the hard evidence that this was a big problem in broadband was very de minimis. And they said, what we're doing, and this is their word, not mine, we're going to act prophylactically. I don't know what image that puts in your head, but anyway. The notion was, well, stuff might happen, and we're going to act prophylactically to make sure it doesn't, okay? Regulation more or less by speculation. Now, the immediate effect on ISP behavior was basically nothing. And that was to some extent by design. People said, well, the standard way that the industry is doing this is we're not having discrimination. We want to make sure it stays that way. So, in essence, they codified existing practice into rule. So, very little effect, but made a lot of people happy, okay? Now, what's ahead for the Wheeler era? Well, broadband is still there. Or is it? Let's talk about broadband for a little bit. I am going to make the no doubt controversial claim that the supply issue of broadband is not there. Okay? 96% of US households currently have one wireline broadband provider. 88% have two, and over 99% have wireless broadband available. What's the problem? Okay? I mean, this isn't everybody, okay? But it never is everybody, okay? This is awfully good, and it suggests if there's a problem, it's kind of a small one. Now, this is a supply side problem, which is there isn't one. But there is a demand side problem. Although we have this stuff out there, the fact is only 70% of US households get wireline broadband. Now, wireless is another story, but wireline. So there's been a lot of concern about this, right? Because all of us tech heads here, we think, why doesn't everybody take broadband? It's so wonderful. Well, not everybody agrees with this, as it turns out. A very recent study is published in January. I think there was somebody from the FCC as one of the co-authors, found, interestingly enough, with a review, with surveys of non-adopters, that 2/3 of non-adopters would not take broadband even if it were free. And just think about that for a little bit. Right away it tells you price is not an issue, doesn't it? Okay. Now, it turns out 30% of non-adopters already have wireless broadband on their smartphones. Now, do we have a problem? I think wired broadband should not be an issue at all, unless we think that cajoling people who aren't doing what we think they should into doing what we think they should is an issue, or an important policy issue. I don't think it is, but others may not agree with me here. So let me put broadband aside. Talk about the next one, spectrum. We're not doing anywhere close to enough. Not even close. This is totally inadequate. And people are talking around the edges and what have you. The two-sided auction is a noble idea. It's very good. I think we should be moving more in that direction, but a lot more. Okay, it's just a lot more. Okay, and we're not even close to that. The sharing idea, when PCAST came up with this about 2, 3 years ago, everybody thought, oh, this is going to get good. We're going to get the feds to share. Okay, what's their incentive to share? Well, the PCAST people understood it pretty well, is if you're in the military and you've got this spectrum and you can use it any way you want, what's your incentive to share? None. These negotiations now have been going on between the private sector and the feds, primarily DOD. Not a whole lot's happening. In fact, the news I get from that is nobody wants to share. They don't need to do it. They don't want to do it. It's their spectrum. They're going to keep it. Right? All you have to do is, if they complain, wave the bloody shirt. Okay? So, I don't think this is going to go anywhere. Okay? Look, spectrum is the future of broadband. It's the future of broadband. That's it. Okay? And it's, in fact, the future of the internet. In my view, wireless has been the one thing that the internet has been waiting for. It's that highly personal thing that we keep on our belts that hooks us to the internet. That's even far closer than wireline, okay? What we're doing is rearranging the deck chairs in the Titanic here. So far, that's all we're doing. We have to get a lot more serious about this. How serious? Well, remember, I'm a retired professor. I don't have to worry about whether we can actually do this or not. Okay, all I can do is tell you what needs to be done. You need to do something big. It has to happen now. Okay? Time to grow a pair, guys. Okay? Here's one simple idea. You may remember back in the 80s and before, right, when we were downsizing the military yet again, and people said, you know, we have too many bases. We got naval bases, Army bases, Air Force bases all over the place, and we have probably 30% more than we need. But every time you bring one of these up in Congress, the local Congress people come out and they complain and blah, blah, blah. So we're never closing any bases. What we did is we formed a base closing commission. And Congress said, yeah, we need to close the bases, but not mine, right? What they did with the base closing commission was to agree that the base closing commission would come up with a proposal for bases to close in total across the country, and it would come up to the Congress in an up or down vote. It was a mechanism to kind of get around this petty lobbying that went on, and it worked. Okay? Why don't we try something like that in spectrum? Here's another thing. We all know how the FCC works with radio license renewals. Your license comes up after 10 years, you send in something, they send you back a postcard, it's done. Why do we do that? I mean, why don't we say, your license is up for renewal. What are you doing with it? Can you sell it to anybody that will be more useful than what you're doing now? If not, maybe we can help you. I mean, here's a simple legal process. It's easy to do. Now, it's not going to happen overnight, but it'll happen if we start it. So we need to start thinking differently about this. More and bigger two-sided auctions. I say if this one works, we've never done this before. One of the things that the FCC has done is extraordinarily well, in spite of some outside interference from time to time, has been running auctions. We really know how to do this. We're really good at this. If anybody can do a two-sided auction, it's the FCC. So that's where I like to go. Network neutrality. Immediate impact's been 0. The intermediate impact I see is somewhat negative, possibly somewhat negative. And that is forbidding ISPs to offer differentiated services is silly. We have plenty of other services, including common carrier services, that offer differentiated services. The post office, for God's sakes, they offer express mail. Do we think that's evil? Apparently not. Okay. Airlines, trains, everybody offers differentiated services. Why not ISPs? What's the problem there? Imposing restrictions like this are really designed to kind of say, okay, we've had this incredibly dynamic thing, and now we're going to freeze it. So it's going to be what it is today forever. Is that a good idea? I think that's not such a good idea. Okay. However, I don't think that's the real problem. This is a small problem. The long-term problem, I think, is actually disastrous. Because one thing you need to understand, with the open internet order and whatever Tom Wheeler comes up with, the FCC has started to regulate the internet. That's what we're doing. The FCC attempted to say, oh no, it's not. ISPs aren't the internet. Right, you can call it anything you want. We're regulating the internet. If you think that's a good idea, you must have loved the old bell system. We've had 40 years of hands-off, and it's been wildly successful. Wildly successful. Hooray for Tom Wheeler. He's taken off Title II Common Carrier Regulation off the table. For now. Okay? But at least some internet regulation is surely coming. Now let's step back and say, what's going to happen with regulation? I mean, God, we've had enough history that we ought to know this by now. A couple things are going to tell us. Number one, regulation will expand to cover the entire industry. Case in point, railroad regulation at the end of the 19th century was expanded in the 30s to include trucking, which is the most possibly competitive industry in the world. Why? Because it competed with railroads. And of course, we covered aviation as well. It expands. It's not because regulators necessarily want it to, it's because their constituents want it to. That's what happens. That's why transportation regulation was extended to trucks, because the railroads wanted it to. Okay? I hope Google understands this. They are in the sights of regulators. They already know this. They don't know how bad this can be. Okay? Look at Title II, look at the Bell system. That's the model. In the shorter run, regulation provides wide open opportunities for rent seekers. Okay? Once the FCC says, we're open for business, people will come into the FCC and they will start requesting limitations on their competitors. That's what they do. You get to use the law to limit your competitors. Rent seekers is what happens. They will do it on new technologies as well. Light squared, level 3, Nextel, Next Wave. Come on. We see it happening. This will become much worse, and this is what will happen to the internet. That's why this is a disaster. You know, the issue of, well, are we limiting whether we can offer high-speed services? That's a small point. This is the big point. And this we should know. Okay, last thing. Oh. Yay, Tom Wheeler. Look, wireline telephony is dying. It's really dying. Less than 70% of U.S. households. I lived in a day where, oh, we have 94% penetration. That's universal service. This is great. 70% and dropping fast. But yet, we still have all the old regulated monopoly, Title II, carrier of last resort, all those obligations. So how do we get rid of that? It's a white elephant. We got to help customers and companies transition. Phase out this stuff here. Voice is quickly becoming an app. That's what it is, okay? Go Tom Wheeler. He's actually stepped up to this. I was kind of amazed, okay? This is like a grungy in the dirt kind of issue, but really important. I'm glad he said he was going to do something about it. Okay, beyond. This is sort of, let's clear our thinking completely. Let's see where we go. People have said this. There's a white paper that really recently came out from the Energy and Commerce Commission, I think, which makes the same point. And it's a point we all know, okay? This is a 1934. Even in the 96 Act, I think the count on the mentions of the count of mentions of internet in the 96 Act was 4. Okay, it was not on the radar. Then it was nothing. Now it's everything. Okay? It's time for Congress to reveal what regulation we need in an internet-based world. And apparently somebody at Congress is actually paying attention. It's kind of amazing. Notice the terms here. What do we need? Not what do we have and how can we tweak it. It's like, what do we need? I'd like to, without being too obnoxious here, just sort of take the table, run my hand over it, everything off the table. What do we need? Let's rebuild it from the ground up. Everybody knows we don't need silos anymore, and so forth and so on. I would go further than that. I would say in much of what we do, I think the network neutrality example is a good one. Curtail or eliminate ex-ante rulemaking. Emphasize competition-based, focused, ex-post adjudication of complaints. And perhaps transfer this whole operation about competition to the FTC, and or DOJ. Do we continue to need silos? Give me a break. The reason we had regulated monopoly was because of the telephone industry, which is now dying. Do we need Title II? I don't think so. Cable regulation, maybe. Merger reviews, we had some discussion about that. Oh, I should say about, when I went to the FCC in whatever it was, 2000, and I thought, finally, now I'm going to learn what the public interest standard is. Now, I don't know, maybe I wasn't paying attention, but I just still don't know what it is. But I'm glad it's so good. Transition spectrum into private-public ownership. Now, there will be needs for the FCC to do some of these things. Certainly the transition out of regulated monopoly wireline telephone, we really need that. We need a transition of spectrum, okay, to both private and public ownership, setting rules, what have you. But we certainly don't need the silos. We certainly don't need regulated monopoly anymore. Here's the deal. If we don't do this, they'll continue to find things to regulate. Okay, even now we're talking about universal service fund for broadband. And everybody knows having it for wireline telephony is silly. Okay, but you know, the numbers I showed you before suggest it's kind of silly for broadband too. But it's something to do. You know, if they're there, they're going to find something to do. And that's not a good thing. Let's start from ground zero and get what we need. Okay, put the appropriate functions in the appropriate agencies and see what's left for an FCC-like agency. Thank you.
So folks, what we're going to do to allow just the conversation to flow is we're going to have Q&A once Larry wraps up and have a conversation both with you and amongst the panelists. So John, if you wouldn't mind.
Good morning. I'm a professor, and when I teach, my students very oftentimes ask me for my slides ahead of time. Now, I don't know what John Sallet had in mind, but when he was doing this, but he seemed to walk you through, maybe it was out of sympathy with my students, but he walked you through my slides. Nonetheless, I'm going to do it again. We're going to do that again one more time. First, I think between John and Jerry, you've heard a lot of commonality and common themes in terms of a lot being on the plate here. There are a number of issues for 2014 and beyond. They include things like the incentive auctions, mergers, universal service, the IP transition, spectrum sharing, the telecom rewrite possibly, protecting an open internet. And collectively, of course, if I think of an illustration that John was so nice to show you, about how policymakers, whether the policymakers are sitting at the FCC or in the administration or down at Capitol Hill, might look. I think of this picture, of this illustration of someone with a huge amount of cognitive overload. And what, by way of sort of unpacking this a little bit, what I want to suggest to you is that when people, and policymakers are, after all, people, when people are cognitively overloaded, they tend to use heuristics in making decisions about how to proceed. And those heuristics can be, I'm going to rely on tradition. I'm going to rely on the way things used to have always been. I'm going to rely, as Jerry said, on who was last in my office making a pitch about my industry or that industry. You can make heuristics on the basis of gender in a variety of personal contexts. You think of heuristics all the time. Policymakers are special. Policymakers have a special heuristic that I want to think about. And let's call this the ideology heuristic. The ideology heuristic. And I'm a professor, I can't help but show just a little bit of data. But here, what I'm going to show you on the vertical axis is a measure constructed by a political scientist at the University of North Carolina, James Stimson, who measures the ideological mood of the American people. And all you need to know, you don't need to know what the units are, but what you need to know is that as you move farther up the vertical axis, the mood of the American people is that they want more government in their lives. And as you move down that vertical axis, they want less government in their lives. And across the horizontal axis, we've got time ranging back from the 1950s coming forward. And what you're going to see here is that mood index has gone up and down. Sometimes American people want a bit more government in their lives, sometimes they want a little less government in their lives, but it goes up and down. That's not so surprising. That's not news to anybody. But what I want you to look at next is an overlay of that mood index with major regulatory and deregulatory changes that have happened over the last 60 years. And what you're going to see is a remarkable coincidence. Indeed, I'll suggest to you that it's not a coincidence at all, that major deregulatory events like the Staggers Rail Act that Jerry pointed out, or intra-state trucking deregulation, or interstate trucking deregulation, or deregulation of the long-distance industry, all happened at moments when the American people were in the mood not to have very much government in their lives. And conversely, we had the Dodd-Frank Act, which occurred at a moment when the American people were a bit more tolerant and had more appetite for government in their lives. And there's work by people in the political science community and the economics community to suggest there is indeed, has been historically a causal link between this mood of the ideological mood of the American people and these policy decisions. Now, why is this relevant for us? As we move forward, as we look forward, there are two things that happen. Number one, we've got critical decisions in this industry. The IT transition, open internet, universal service, and so on. The litany just goes on and on. If what happens as we move forward is that we allow the ideological heuristic, I'll call it, to make decisions for us, then those decisions will be held captive to the mood at a particular point in time of the American people. Not that it's good for economic policy, not that it's good for consumers, not that it's good for economic welfare, but rather simply based on the mood at a moment in time which will surely change. So that's a problem, I think, if we rely on the ideological heuristic. The second problem with the ideological heuristic as we move forward, if we base policy on it, is that it is, let's call it, indiscriminate with respect to industry. When the mood of the American people is for more government in their lives, they don't care if it's telecom or furniture or trucking or railroads. They're going to either put the regulatory lever down or up. And unfortunately, what that does is to bring a regulatory broom, either sweeping regulation in or sweeping regulation out, that catches all industries. It doesn't catch industries that says we're going to regulate, turn the regulatory dial up on poorly performing industries and turn it down on well-performing industries. It's going to sweep all industries with the same broom. And that would be very, very unfortunate for the future. Now, this notion that the ideological heuristic has been in play is not brand new. It's not brand new. Indeed, I can date it back to at least John Stuart Mill, famous political economist from the 19th century, when he said, "There is in fact no recognized principle by which the propriety or impropriety of government interference is customarily tested." No principle at all. People decide according to their personal preferences. He goes on to say, "And it seems to me that in consequence of the absence of a rule or principle, one side is at present as often wrong as the other. The interference of government is with about equal frequency improperly invoked and improperly condemned." That suggests that on average, as you move forward, we're just going to have the chance of getting it right or getting it wrong about, if John Stuart Mill's right, about half the time. Again, depending on whatever the mood of the people is at that particular time. But John Stuart Mill also uses a very critical word here in the first line. He said, "There's no recognized principle." So with a little bit of humility, let me suggest to you that we can indeed look to and turn to a set of principles. And I'll try to go through these relatively quickly so we can have some time to talk about them. But these are from a paper I did last year on the evolution of regulation, in which I proffered a notion that if you look to the best of what has been working in the regulatory construct, it has been that regulation at its very best has been results-based. Some people use the term fact-driven, results-based here. And the principles that I'm going to offer as guidance for going forward that might do better than an ideological heuristic are as follows. Number one, all market governance mechanisms for resource allocation are in practice imperfect. Let me repeat. All market governance mechanisms for resource allocations are in practice imperfect. Now, this is an obvious point, I think, but it's one that we in Washington consistently ignore. As we listen to arguments, all too often what happens is people that want to turn up the regulatory dial point toward imperfect markets with the assumption that there is costless and perfect regulation that's going to fix that problem. Or conversely, people that want to turn down the regulatory dial point toward imperfect regulation and costly regulation with the implicit or explicit assumption that markets are perfect. And the reality is neither of those is true. Markets and regulation, markets and hierarchies are both imperfect in that context. You need to roll up your sleeves and figure out which one works best in practice as we move forward. Number two, given the advances in technology and the presence of evolving legal institutions, regulators must be vigilant to the possibility of improved regulatory or deregulatory designs. This dovetails with what Jerry suggested. This is a notion that the world is, in fact, changing very rapidly. It's changing very rapidly in a technology context, and Jerry highlighted some of those, moving from a wired to a wireless world. And really critically important and very likely to be overlooked if we don't just pound the table with this, is that there's been an evolution of legal institutions and enforcement institutions in this country that have to be thought of as changing the optimal mix of how we construct policy in this country. Jerry mentioned the maturation of the Federal Trade Commission and the Department of Justice as enforcement agencies with strong capacities and capabilities of enforcing competition policy. Third principle, wherever possible, regulators should engage in empirical, counterfactual scrutiny of alternative market governance mechanisms. They should engage in empirical, counterfactual scrutiny. Why do I say this? I say this because among all animals on this planet, human beings are the only animal that has the capacity, the intellectual capacity, to engage in counterfactual thought. A dog can't imagine an alternative state of the world, I don't think. A cat can't. The smartest chimpanzee cannot. But policymakers can. We can imagine a different world, and we can imagine a different world by looking cross-sectionally at how has it worked in other alternative contexts. The federal government might learn something from what is being done in California or Minnesota or Massachusetts. Massachusetts might learn something from what's happening at the FCC. The FCC might learn something about what's happening that works well from the FERC. Or we might learn something from the Europeans, or vice versa. And we can also learn intertemporally. We've had light touch policy in this industry for a long time. How's that working out for us? If it's working out for us, then it changes the nature of regulation and smart regulation as we move forward. Fourth principle, in assessing the merits of alternative market governance mechanisms, policymakers should weight granular empirical evidence collected from actual markets very heavily. Here, what I'm suggesting is that there is a role, an important role for economic theorizing. I'm an economist. I'm not ready to give up my credentials at this point. But it is beyond the capacity in many contexts of high-level theorizing to be a basis for fashioning granular policy as we move forward. Instead, we ought to, I believe, look at empirical evidence. One could talk, for instance, about how concentrated the telecommunications industry might be. And that might create a worry. But as we know from economic theory, concentrated markets may be either robustly competitive or they may be sources of anti-competitive behavior. That doesn't really help us a whole lot. What might help us is how are firms actually performing? How are they behaving? Are there choices? Are consumers switching? Is there rivalry in the market? Those are things that we can look at and measure and calculate for moving policy forward. Final principle, when considering alternative governance structures for a market, policymakers should focus on tangible end-state metrics. Here, what I mean by end-state metrics, alternatively, you might think of as called retail economic metrics. There are things that I believe don't really matter, that regulators all too often focus on. They focus on what share of the network is fiber, is copper, is wireless. And we're going to write regulations to alter the configuration of a network. That's not what consumers care about. What consumers care about are things like prices, output, investment, innovation. And those are things that really can matter and do matter for policy. They're retail economic metrics, and those might help guide policymakers. Again, policymakers, whether they're in Congress with a consideration of the rewrite of the Telecom Act, or in the administration, or at the FCC. So just in closing, let me just say the title of this morning was on fresh thinking for 2014 beyond. I think we are at a risk in this country of incrementally allowing what I refer to here as an ideological heuristic to drive policy. And in fact, I think we can move beyond that. We really can learn some lessons, the best lessons from the evolution of regulation over the last 50 years by relying on these principles as we move forward. Thank you.
Mr. Downs, as our representative from the West Coast and Silicon Valley, curious as to what your thoughts are.
I'll go up just, even though I don't have any slides, but maybe it'd be easier to see.
You won't need this, then.
I won't need that. I could reuse your slides. In fact, I could reuse both your slides because they were so good, and you sort of took all my material away, which means I'll have very little to say. So I'll keep this very quick. I found all those presentations really helpful and extremely engaging, and I agree with almost everything that you guys said. And it was nice to get the details and the sort of theory together. I just want to put just sort of as Carolyn suggested, a West Coast perspective on what you've heard, and that is to talk a little about this 3-year research project that I've been involved with colleagues at the Accenture Institute for High Performance on the changing nature of innovation. We didn't look exclusively at the internet ecosystem, but we looked pretty extensively at it since it is probably the best example we've got in many respects as a sort of a laboratory for how innovation happens and how it changes over time. And I think, you know, just to put this down to our principal finding, none of which would be surprising, is what we found is that the way in which innovation is now happening has changed in a way in which it becomes faster all the time. And largely that's because we've had several now decades of improvement of what we call exponential technologies. We have some core technologies. Obviously, computing technologies is one, although it's not the only example of technologies that get better and cheaper every iteration. And the iterations in the case of computers is, roughly every 12 to 18 months per Moore's law. As you sort of start to have that happen on a continuing, indeed, in a predictable basis, it changes the way in which new products and services get developed, in which they enter the market, and in which they exit the market at the same time. And if I was going to put up any chart here at all, which I apologize, I don't have it in front of me, but I would start with this very famous chart from 1962 from a sociologist named Everett Rogers, who wrote extensively about the way in which new technologies diffuse into the markets. And basically, Rogers' model was sort of a bell curve. He said it starts off, because it's new and expensive, it usually starts off with what we call early adopters, people who are willing to pay more for less just to have the kind of the privilege of being the first one on the block to have whatever the newest thing is. If you think about personal computers, the early days, it was really literally hobbyists. You had to put it together yourself. It didn't work. It was very expensive, and it really was more for the privilege of saying you had a computer than anything else. And then in the Rogers model, that sort of moved through to mainstream markets, and then ultimately to what he called the laggards, who were kind of the last people to adopt a new technology. Well, the problem we found is that because of this kind of long history now we had of exponential technology improvements, that bell curve has kind of been squashed and stretched at the same time into a shape that when we drew it looked remarkably like what we then refer to it as a shark's fin, where you had sort of a flat period, lots of experimentation, most of them failed experiments where people tried to work with new technologies, just didn't make it at all. It wasn't like they were partially successful, they were completely unsuccessful. Think about e-book readers. We had a decade of completely failed experiments in electronic readers from lots of different big and small companies, and then magically one moment Amazon figured out the secret sauce with the Kindle, and then you see what happens is the market, of course, is now primed for this because the consumers have been hearing about it for a decade. They know when it comes and they see what they like, they're going to adopt it. And so instead of this gradual uptake in a bell curve, it's basically straight up. And everybody who's going to adopt a new technology does so in a very short amount of time. We're talking about apps on smartphones, literally it can be days. We're talking about games, it can be literally weeks for this life cycle to run its course. For hardware, it's obviously a little bit longer, but still, with the e-book readers and other examples, it's remarkably short. And then, of course, because you've got that saturation so quickly, then the exit is also pretty quick. Not quite as quick, but they're going to wait for the next thing, and when that next thing arrives, very low switching costs, people will move on. You see this, of course, in the smartphone market all the time. Today's leader is sort of tomorrow's has-been. There may be resurrection possible, but it's all clearly based on sort of big winner-take-all markets and topics. So that kind of, I think, has informed my perspective on these policy questions. And the title of this, as John just mentioned, was Fresh Thinking. But actually, I think probably my fresh thinking is to reiterate a lot of old thinking that has happened. I think the principal point about how this affects regulation is to suggest that when you have markets and industries and consumer behaviors that are increasing their disruptive capability faster all the time, the last thing you want to do is to impose a slow-moving regulatory process on that. So sort of, consumers get faster, regulators stay the same pace, the likelihood of sort of intersection accidents gets greater, and that we certainly have seen that. And so as I think about how we look about communications regulation for the coming decade, what I would like to see is sort of more of what happened and maybe unintentionally happened in the past, and that is very little. We talk about the idea when the internet was first becoming commercial, both the Clinton and Bush 1 administrations had a policy, sometimes explicit, of first do no harm. It's an emerging market, it's a rapidly changing market, it's only gotten more explosive since then. Don't regulate until you understand what's going on, don't regulate until there's actually a problem, and don't regulate until you've got a solution that costs less than the problem itself, as John suggested. I think that's an approach that has worked, and sometimes intentionally and sometimes unintentionally. The 96 Act, as Professor Faulhaber mentioned, doesn't mention the internet, but in passing, that may have been because they didn't know too much about it and they didn't know it was there. But it wound up being a wonderful thing that happened, because essentially the market was left to develop on its own, essentially at the pace of the technology. So the exponential pace, as the pace that we've been experiencing, it has not been slowed down intentionally or unintentionally by a regulatory framework that just by its nature has to happen more slowly. We have also had, again, as has been mentioned, this backdrop of antitrust and anti-competitive law that's already on the books and is understood and quite mature, operating in the background. It's been applied, frankly, more frequently than not so much in the communication sector, but certainly to app providers, to hardware companies. We've seen FTC be getting much more involved in privacy matters as opposed to software and things of that nature. And it may be, in fact, that backdrop of anti-competitive law has been what has really been kind of the discipline behind the quote-unquote unregulated or light touch internet ecosystem, that we sort of know it's there and that it can be applied, and that was all the incentive that the industry needed to more or less behave itself. Obviously, the result of that has been, we've seen that the vast majority of innovation that's happened in this space has been US generated on whatever dimension you want to look at, so much so to the point that we have now other countries and other regions trying in various ways to, in fact, to take control or to cripple US interests, either through governmental means or through protectionist legislation at home. So the final point on this would be to suggest that and again, to use the word that Professor Faulhaber mentioned from the Open Internet Order, the worst kind of regulating we could do, if we're thinking freshly about the communications industry, is prophylactic. Certainly, there's not to suggest there aren't market failures that can be solved through regulation on a cost-effective basis. But when the market is changing so rapidly that even the developers that are doing it don't know what's going to come, clearly regulators and policymakers aren't going to know any better. And so trying to guess ahead of time what kind of failures were happening and then to regulate for them is probably the most likely to lead to unfortunate and unintended consequences. And in some ways, you know, just to wrap up, when we looked at the Open Internet Order, it sort of got this right. The FCC started that process back in 2009 by asking, you know, since it didn't have any real experience with the internet or broadband or ISPs, because the 96 Act didn't really give it anything to do there, it started by asking the series of questions about, well, what is the state of the market? What is the technology? How does it work? What happens and what doesn't happen? And the result of that research is sort of found in the back of the order. And what you see is there are at least a dozen exceptions, some very general, some very specific to the rules that were promulgated and then later thrown out. But they realized things like, oh, there's specialized services, there's content delivery networks, there's other kinds of network management, there's interconnection agreements, there's co-location agreements. There were kind of, you know, more or less a dozen of these non-neutral behaviors that the FCC understood were nonetheless essential for the kind of successful operation of the network. And the problem really was that they didn't kind of take it the next step and say, well, there will probably be a dozen more, many of them engineering-based and technology-based, that are going to come up in the course of our rulemaking. And there's no real provision to say, all right, you know, these exceptions we allow, that's good, but then what happens for future exceptions that are going to be necessary? I think that was the problem, and that's the real problem with prophylactic rulemaking in the first place. So I'm going to stop there. I think everything else was already said quite well, and give it back to Carolyn so she can moderate us.
Thank you, Larry.
Thank you.
You know, what obviously you guys each had prepared remarks, but before we get into a conversation about what you guys actually discussed, I just wanted to get the sense from each of you what your thoughts were on the 4 principles that Jonathan was discussing, that we've heard the new chairman, Tom Wheeler, articulate, that were given effect in some work done by Commissioner Rosenworcel. You know, do you have any commentary or thought about that, and where do those principles, I mean, are these the right ones that should be driving the thought process going forward? John, you're nodding most vociferously, so we'll start with you.
All right. So what I've found interesting, but also was a point of tension in that discussion, was that I didn't have any trouble at all accepting, as a matter of good public policy or as an economist, the principles that he identified that Commissioner Rosenworcel also laid out. I think that's really actually very healthy to be rather specific about what policies the Commission would like to pursue. The tension that I had was in translating from going from there to the public interest, what is also called the public interest standard. And the question that I would ask is, okay, is this the sum total then of what we'll call the public interest, or are there things beyond those principles that constitute the public interest, and how do we know what they are? And the reason I say how do we know what they are is that I think that as the firms that Larry spoke about or Jerry spoke about are trying to innovate, they're going to have the very issue of trying to understand the public policy framework that they're operating in. And if they don't, if there is a big slip, let's call it between cup and lip, between those principles and something called the public interest, then I don't think that's going to be good for consumers, and it's not going to be good for the companies, and it's not going to be good for innovation.
Jerry, you had some thoughts on the amorphous public interest standard. What do you think?
Well, yeah, I mean, you know what I think about the public interest standard. So, the notion that I think John's got it right. The principles are good. Okay, what matters is how is it going to apply in mergers, spectrum, and it's not immediately evident. I mean, it could go a lot of different ways, and that's where the rubber meets the road. It's, you know, the retail economics of it. Principles are fine. Okay, that's good. I'm glad we all have religion, but you know, when the rubber meets the road, what do we have? And that's not clear from that to me.
Larry?
Yeah, I'm desperately searching for something to disagree with to keep this more interesting. I think, yeah, they're all fine, except maybe for the last one, in terms of consumer protection. Not that I'm in favor of not protecting consumers, but that given the nebulousness of the public interest standard, consumer protection often turns into competitor protection in the guise of consumer protection, and often, you know, filtered through a lot of layers of disingenuousness. So that's the one that worries me. I think that's the bucket that captures everything and anything, and probably, you know, the one that if you were actually going to sort of map this out in the future and they said, how did they do, you know, report card on how they did, I think you'd find the most mischievous behavior would be in that fourth one.
Please.
That's a very good point. I'd like to get back to that. We have consumer protection at the FCC. We have another agency which is actually more or less in charge of consumer protection, and that is the FTC, which has also looked at issues of privacy, where they're probably ahead of the FCC on that. And another issue which is near and dear to my heart is transparency. Now, I think all those are very good things. I don't think we need 2 agencies doing them. And I think we need one agency, and it's probably the Federal Trade Commission. I would not be adverse, in fact, I would advise that we have some people at the FCC who have very specific industry expertise that could well transfer to the FTC and address issues like transparency, privacy, and consumer protection. Again, I'm all for that. This is a good thing, and I've spoken before about how important transparency is and how important it is that we probably are going to need some regulation like we're getting from the FTC about issues like that. So I'm not against all regulation. Transparency, I think, is a very important one, as is consumer protection, and I think eventually privacy, which is still an issue we're sorting out in this country. But I think where that belongs is the FTC.
So John, you talked about retail economic metrics, not a unique topic, but as folded into this conversation and matched up with an idea that, Larry, you have talked about, which is the fact that in many markets you have almost near perfect information available to the consumer. The challenge, I think, John and everyone here is agreeing to is this, amorphous nature of what exactly is the public interest statement, or public interest, where does it match up with the principles that are articulated, and how will it weigh in terms of the development of how those principles are applied. The reason I focus in on retail economic metrics, as you and I have talked, is what we often find inside the Beltway is you can have a very specific fact that has been attested to by lots of experts, and you have two different parties who look at that same reality and come away with very different interpretations and spins. An example would be some of the facts around the wireless experience here in the United States. I think earlier this week we saw a lot of discussion in both popular and trade press that some of the characteristics that many in the United States would point to as showing very healthy metrics in terms of consumer demand being satisfied, prices going down, output going up, tell a very positive story about wireless broadband in the United States. However, CEO of SoftBank took a look at those same stats and walked away and was telling a very different story, that there is a fundamental problem with the structure of the industry. He sees a lack of competition, he sees a failure of spectrum policy, et cetera. So I guess the question I tee up for all of you, maybe John, for you first as a professor, is how is it in the conversation with policymakers inside the Beltway when you have very different ways of interpreting and torturing the facts? Do you actually get to a fact-based discussion about a particular policy?
Well, I rather like the idea of going back to the principles that I just spoke about. So one of the things that we have is not actually people disagreeing about the same fact, but arguing about different facts. So you can assert with some certainty that the wireless arena is relatively concentrated as an economic industry. It's relatively concentrated, and people can speak to that. That's the sort of high-level theorizing that I spoke about earlier. What you make of that really is rather ambiguous from an economics perspective. What I would find more compelling is if we actually did have a discussion about what the real economic facts are, and on the lines of retail economic metrics. So looking specifically at what the heck has happened to prices, because consumers actually do care about prices. And there it would be an interesting debate, and it doesn't end the debate, you're quite right, to say, well, let's talk specifically about prices. Prices as a factual matter have dropped precipitously in the wireless industry. But if you want to have a discussion and say, well, I'm not persuaded that we have the right governance regime because counterfactually, and that gets back to another one of the principles, counterfactually, I want to argue that prices in a different regulatory regime would have fallen even more, then we can have that discussion. But that would actually move the debate and dialogue a bit forward, I think, if we actually had a discussion at that level.
Jerry, Larry, any thoughts?
Well, John knows that my touchstone on all economic matters is the late great Ronald Coase, who famously said, "If you torture the data long enough, nature will always confess." But I don't think that's actually what was even going on this week. It was not a question of interpretation of different facts. A lot of it was no facts or made up facts. And so, the simplest is let's just, all right, what are your facts, Mr. Sohn, and what are the sources for them? And let's look, in fact, when you say this is the case and this is the case, do you have anything to back that up? Let's actually look at the data. Now, the more sophisticated problem is when you start to manipulate the data to make it tell a different story. That's a much more complicated conversation, but I don't think that's the conversation that we were having this week.
Let me pause and ask if there are any questions from any audience members. And I would just ask, if you do, if you could grab the mic and introduce yourself before you ask the question, because we're live streaming.
Given the comments earlier, my name's Natalie Lara Lopez, by the way. Given the comments earlier about the value principles that are enduring, where would you place minimum value of security on the services being offered by the industry? For example, there's the Executive Order 13636, and in that, telecommunications is highlighted as a critical industry sector. Part of the challenge with that is it's in fact voluntary, and each entity is able to confirm or assert their posture. So they create, in essence, their own data. Where do you see the public interest, value statement or consumer protection weighing in on, that need to establish a normative baseline that is more objective and less subjective?
I'm just the moderator. I don't have to answer,
Oh,
so go
it
ahead.
depends what you mean by security. I take it you're not referring to NSA type security, in which case there's a whole set of issues everybody in this room knows about, and have a huge impact on the public interest, almost however defined. The issue of security, not just communications, which I don't think is the big issue here, but basically software and hardware firms, the targets, these are the kinds of things you're looking for. This is a problem we haven't come to grips with as a society. It's one thing to say, well, does Target provide security against mugging in its stores? And we kind of have the standards for that. What should they do? What should they do about getting your data stolen? We don't know. And we don't seem to be looking at it seriously enough to say, okay, what should we be doing with companies? Should we be dealing with this through regulation? Should we be dealing with it through some form of corporate responsibility, if that requires you to say, pay for people's identity theft insurance for the next year? And we're kind of groping our way towards that, but that's what we're doing. We're groping our way. I think it's very important we sort this out. And again, it might be the FTC. Probably Congress is going to have to do something about this, because these problems are not going away. And I actually got a call from Target saying, do you want this free stuff? And my response was, number one, you're doing a great thing by doing this, by publicly saying you've got a problem and that you're going to try to fix it. Because we'll see, I think it was Experian recently, it was revealed they lost a ton of data. I mean, like 400 million records, okay? It's like, what are they doing for me? Because I'm sure my credit history is in Experian. What are they doing for nothing? Okay, so we need to have a kind of a common way to say, what's companies' responsibilities? What are individuals' responsibilities? How do we deal with individuals' data? In Europe, presumably, you have some ownership rights to your data. Here we don't. It's like whoever grabs it owns it. So are we still going to continue that? I don't know, but that's an important public debate we need to have.
May I just follow up? I would say that I'm delighted that the President has put this emphasis in this area. And I would agree with Jerry in the sense that we are just at the very incipient stages of beginning to wrestle with this. It's one thing when bad actors, whether they are state actors or corporate individuals, want to hack in, and we put our technical people against their technical people, and that's a very good thing. What we haven't yet begun to do is really deal with the question of how do we shape economic institutions and economic policy to create incentives for the targets of the world to undertake the appropriate level, and that's a hard thing to decide or define, but the appropriate level of security, especially in a world where there are risks that if an attack happens at Target, bad things don't just happen to Target. If it starts to undermine the credibility of the retail system or switch it over to telecommunications or the financial sector, undermine the integrity of the financial network, then we've got much bigger problems than any individual firm faces. So I think we're just beginning that process. It's something we really need to emphasize.
So we've got two questions, one in the back, Earl, and then Anna Maria.
Thank you, Earl Comstock. Question, as a panel of academics and I take it economists, I'm for full disclosure, I was one of the staff that worked on the 96 Act, and I'm just fascinated at the continued repetition of the fact that Congress knew nothing about the internet in 1996. As academics, I think you would have gone back and researched that a little bit more. Congress and the FCC had been dealing with the internet entities for decades at that point. And I just point you to the High Performance Computing Act, the Spectrum Auction legislation in '93, the discussions in '94, '95, into '96. The internet was clearly featured. It was front cover of Time magazine, front cover of Newsweek. So there's plenty of data out there to point you to the fact that not only was Congress well aware of it, so was the public. The reason I would say we didn't talk about the internet specifically is because I see a mixing of the applications and the infrastructure. And the Act focuses on the infrastructure. And so as economists, I'm surprised that you haven't commented more on the barriers to entry, both in wireless and wireline. This goes to the discussion that Mr. Son was having about the number of wireless players you have. The reality is that there's a gigantic barrier to entry in building a nationwide network, whether it's cable, it's telephone, it's wireless. And I'd like you to comment on that because I think it's an important element that's really missing here. A lot of your analysis is focused on what do you do about the applications, and I agree, that's a concern of how you regulate that. Maybe that is the FTC. But the focus of the FCC should be on that infrastructure layer, which was well understood in 1995, 96. There was a lot of discussion about the bearer layer, and the reality that TCP/IP is really nothing more than the separator between those two and an agreement to use a common protocol. So I'd welcome your comments on that, but I also think it's important to correct the record that Congress was fully aware of the internet and discussed it extensively if anybody cares to look at the record.
I must confess I did not look at the congressional record, but I think the broader issue being discussed here is what do we feel about infrastructure, barriers to entry, and what have you. I'd like to focus on wireless because I think that's the most interesting case. Building a national wireless industry is subject to scale economies. There's no question about it. This will never be an industry with 20 or 50 firms in it offering things nationally. We've seen entry into this business, and interestingly enough, we've seen entry by people who own some spectrum, but not a whole lot, and they basically have roaming agreements with others. That seems to work out. It doesn't seem to get, well, in Philadelphia, I think we now have 7 wireless providers. We tend to concentrate on the top 4, in which case the SoftBank guy, I'm very happy if he comes in. He'd be a great competitor. Or even the top 2. And forgetting that there is entry into this business and that that's important. And it's important, incidentally, if there's a role for the FCC to be able to maintain this without attempting to tip the balance by saying, okay, Verizon, AT&T, you can't bid in the next auction. I think that would be a disaster. But to encourage, I would like to see, for example, I don't think this is ever going to happen, but the FCC has been talking about unlicensed spectrum and saying, isn't this a wonderful thing? We're going to have more unlicensed spectrum. You know, when I can buy a phone that works over unlicensed spectrum and call other people, then I'll say it's a great thing. So maybe we could do something other than simply the white spaces experiment to turn some of that into more spectrum, more available, and more competition. I would like to see that happen. I probably would not be real excited about seeing mergers in the wireless game. Okay, I think that's something we probably want to hold off on for a while. But we are going to have, it's going to be a concentrated industry. It's subject to scale economies. It's like the automobile industry, right? What do we have? 3 major domestic suppliers, and we have a few other people making cars in this country. We have maybe 6 or 7 cars being made in the U.S. It's not going to get more. It's a big business, and you have to understand that, and you have to police it. And that has to be done in wireless. I don't think there's any question about that. But that's, there are, you know, when you say there's barriers to entry, the barriers to entry are scale economies. They're really economics. They're not like phony barriers to entry. Okay, they're real. And, you know, you need to deal with that.
Just a couple things. One, thank you. I think your comment really does highlight exactly where some of the tension is of what people want to focus on and perhaps what we can focus on. Barriers to entry are an important issue in economics. They really are. But that's not what I would have called a retail economic metric. It's an important thing to look at, but, and Jerry described why they might be more or less an inevitable part of a wireless network. But let me just suggest that the same thing that you indicated about the wireless network would have also been true on the wireline side. Barriers to entry into the wireline side are very high. As you know, you worked on the Act. They're very high, and yet today we have millions, tens and hundreds of millions of people that are abandoning their wireline phones, going to wireless. That source of competition didn't come from the diminution of barriers to entry in the wireline side. It came through emergence of technology and technological change. So I think we have to be careful in running the words barrier to entry up the flagpole to just go too far with that. That would be my only point.
Anna Maria?
One of the points, and I'm Anne Marie Kovacs with this Georgetown Center. One of the points that Jerry made was that once you start regulating, it expands into adjoining areas. And I'd be interested in hearing particularly, well, all three of you, but perhaps even more the other two, talk about some of the potential dangers of regulation expanding into the application layers. But Google Voice, I think, was one of the things that Jerry sort of mentioned along the way.
Yeah, well, so I'll just key this back to the point I started with, which is that the shape of this innovation curve has now become this shark fin. And one of the things that you'll notice very quickly is in a winner-take-all market, it starts to look within a matter of weeks like you have an antitrust problem. And so if you are, for example, you know, the company that excuse me, that Facebook is about to acquire, in the process of acquiring the WhatsApp, there were dozens of these these sort of internet-based text services. This just happened to be the one that caught fire, and now has something like 400 million users, completely dominating everything else in the space. Well, if you were going to kind of apply a traditional antitrust look to that, you'd say, oh, this is a big problem. Except if you know that the curve is going to crest and then start to come down and something else is going to take over, you realize what looks like an unsolvable problem of market dominance is in fact a transient problem that the market is going to solve and solves all the time. This is something that happens a lot at the edge and the application layer of things in software. And so I think, to me, the risk is if you start to expand the idea of internet regulation, if you're going to bring those old models of concentration and the old tests for concentration and start applying them to, you know, the latest Zynga game that everybody is playing, you would see a lot of problems that need immediate resolution that actually don't.
John?
I'm good with what Larry said.
Well, we are actually at our time, and unless there's a burning question from the floor, I think we can go ahead and have a wrap on this conversation. I think more to come, certainly from the work of the various scholars at the center, and please stay tuned. And please join me in thanking our speakers for a really interesting conversation today. So thank you all.